You are an expert, perhaps a scientist, and perhaps used to a logical presentation of information. Going into a deposition, you have probably written your expert report in just such a methodical way. Some attorneys will ask you questions that track your expert report from beginning to end. Others will not. The better you become at responding to questions and understanding the testimonial arena, the more open-ended questions you will begin to hear. They will encourage you to ramble through answers that do not directly lead you in a particular way. You should be prepared for such open-ended questions. If they have learned well, these deposing attorneys will probably jump right to your opinions, have you enunciate each one, and then ask you to tell them what you did to reach each of those conclusions. For each opinion, they may repeat the same sequence of questions. What exact procedures did you follow, Mr. Expert? Can you explain those steps further? They may well ask you at this point, what steps did you not pursue and why? Can you tell us about the results? For every result, they may ask you to ramble on about how that result affected each opinion you offered. They will ask open-ended questions about what assumptions you made in your explorations. You will not necessarily hear all these questions, but you should be ready to answer any of them. At every deposition, a well-trained attorney should probably ask you each of these questions. You should be prepared for a series of related and additional questions, such as, question, who chose the materials you reviewed, Mr. Expert? A key tactic to note here is that generally when you start a case, the attorney sends you miscellaneous documentation to review to come up to speed on the case. If you are new to the expert witness arena, you will probably assume that these documents represent all you can or should review. That is completely false. It would be a major error on your part to assume otherwise. Once you begin reviewing materials and begin to understand the elements of the case, you should be prepared to ask your attorney for any other materials that you feel are appropriate or necessary to the formulation of your opinions. There will be times when you realize later that certain other documents must exist because documents that you are reviewing refer to them. If you think those additional materials are relevant to the opinions you're working on, ask your attorney to provide you copies of them. There will be times when other materials exist, but you have not yet seen them. They may be relevant, and the attorney may already have access to them. Ask if there are any other relevant materials that you have not seen yet. That's a good question. Keep that in mind. Ask the attorney if there's something else you haven't seen that is relevant. Ask for them, get them, review them. Only then can you decide whether they are relevant. Question. Mr. Expert, what else did you consider in your opinions but eventually decide not to rely on? You should be careful in your response to a question like that, because you have to have solid reasons, like irrelevance, for having excluded something from your eventual opinions. The reasons cannot be simply that the material would help the opinion of the other side in the matter. Attorneys learn to ask these starter questions of almost every witness. Other questions exist, and I'll cover the principal additional ones in Lesson 9.